the July 18th meeting of Title IX coordinators. This was a hot topic of discussion at that meeting, and so I am pleased to have so many of you join us again today for some further discussion and information from Amy on the same topic. A couple housekeeping items before we get started. If you can or have not already muted your phone or your WebEx application, I ask that you please do so to minimize any disruptions throughout the webinar today. Also, in your application, you have a chat room that you can pose questions to Amy as a presenter at any time during the presentation. I will monitor those questions as I can from my end, and we'll let her know if we need to pause for a minute before moving on to address any questions, or certainly we can get to them at the end. Also, if you have a tablet or a phone that you are working from as you listen in today, I ask that you just keep that item away from whatever device you are listening in on the webinar from. We have had some issues with feedback in the past as a result of that. And then also just a reminder that I am recording this webinar today, so it will be available to you or anybody else upon request. Just email me directly at the conclusion today, or anybody else who on your campus you feel should listen in, or who you would like to have access to the information shared by Amy today. Just a means of getting started before I turn it over to Amy. For those of you who do not know, Amy Zavadil has served as a Title IX coordinator at 2 different institutions and serves as a member of the advisory board for ATIXA and is currently working as an independent consultant. So Amy, thank you so much for your time and talents today. And with that, I'm just going to turn the presentation over to you.
Great. Thank you, Carrie. I appreciate being here. You can go ahead and flip to the next slide. So when Carrie and I talked about providing more information about informal resolution, as many of us anticipate there's going to be an increasing need for informal resolution options, there's a lot to think about, and I want to provide a couple of things up front. The first is I want to offer a framework for us to think about informal resolutions. We'll talk about some decisions that are going to need to be considered at the institution and department level in order to inform your practices. We will review some of the types of informal resolutions that are out there, and I'll also invite you all to share some of your thoughts as we get into that. And probably most importantly, the spoiler alert is to expect that you're going to leave with questions. The challenge is this is an emerging area, and although it can be informed by a variety of existing practices, it's not clearly defined, and there is not an anticipation that OCR guidance or the final rules are going to clarify this. So this conversation is the start of a conversation, and hopefully will help folks with some framework and some additional things to think about, some ideas, and will lead to, I'm sure, some more opportunities for information sharing moving forward. So let's start with informal resolution and what does that mean? They're really part of the challenge is there is not a single definition of that. And so I've kind of pulled from a variety of places some definitions to think about, looking specifically at what information the Department of Education has afforded. It refers to an option for resolution that does not involve a full investigation or adjudication. It also emphasizes that it needs to be voluntary. So that's broad and leaves a lot of questions and leaves it up to us at institutions and practitioners in the field to define in the context of the work that we're doing. I've pulled from a variety of other places. So here in Ohio, many of you are familiar with Bricker and Eckler, who provides a lot of free webinar access to higher education folks. And they did a workshop, I think it was back in May, around informal resolution. And their definition here on the screen refers what I provided emphasis of, specifically a Title IX complaint, encouraging some thought around here in the Sixth Circuit. The distinction is going to be increasingly important of, is it a Title IX complaint or is it falling under some other policy or process at the institution, because we certainly have some increasing case law that is giving us some feedback around what the courts are expecting of schools. But Bricker and Eckler did a nice job of talking about the spectrum of methods that can be used to resolve a concern without formal investigation and determination. Next slide. From student conduct, for many of us who may have started or spent some period of time of our work there, certainly informal resolution is referred by some as a conflict resolution or alternatives to a formal disciplinary process. And I put the caveat there that in some people's student conduct models, an informal resolution could also be when a student accepts responsibility. So it is still disciplinary, but is resolved informally. So on some campuses, there may be a little more nuance to think about there. When we look at legal realm, informal resolution can also be referred to as alternative dispute resolution that offers an alternative to some formal adjudication process. And this may include mediation, and we'll come back to that concept as that has come up in the last decade when we talk about Title IX and sexual misconduct in particular. This is also a point I intentionally paired student conduct and legal perspective here together, because those of us who do this work having come from conduct and student affairs, this creates some fresh dissonance that we've been working on for a decade. About a decade ago is when student conduct really shifted away from judicial models, and some schools were quicker than others to really take all that judicial language out of our conduct processes. And now some of the conversations around Title IX and informal resolution are putting us back in this place of using legal language, or should we use legal language, and what does that look like on each of our campuses is another point to think about. We can move on to the next slide. So the other place to look, particularly because increasingly sexual misconduct is falling under a centralized office that is working not just with student resolution, but faculty, staff, and students, is from Human Resources and EEOC. And of note, the information on the screen is from the EEOC with regard to how the Equal Employment Opportunity Commission would respond to someone bringing a complaint forward to them. But that informs how HR approaches their work. And I think what's important here is to look at an informal resolution freely arrived at by parties, that we're talking about a dispute and we're talking about the voluntary engagement of parties. The other thing that this definition, as well as the Bricker and Eckler definition, are specifying a concern of discrimination or retaliation, or Title IX specifically in the earlier example. So this really speaks to there needs to be some gatekeeping. What are the behaviors that would lead to or would be eligible for an informal resolution when we're talking about it in this context? And this may be one of the first points that on an institution really needs to be given some thought. I know I've worked at institutions where if somebody has a concern and it may not be a policy violation, there are certainly options of wanting to help resolve those concerns. And often people refer to that as an informal resolution. We might need to be careful with how we're using language in that way as we create greater need and expectation of having informal resolution options specific to resolving concerns of sexual misconduct. So beginning of some things to think about. All of these are talking about a broad approach of how do we move forward to provide options that are short of or in lieu of formal investigation and formal disciplinary action. And again, that may align with how everyone thinks about informal resolution, but there are others who may need to really clearly define that if you have other forms of informal options that do fall within the spectrum of conduct resolution or HR processes. Next slide. So broadly speaking, the elements to think about, and this may be the first place for you to make some notes of what are the decisions that might need to be made on your own campus, is the questions about what are the elements of informal resolution. clearly, almost every one of the definitions on the screen that I shared reference the voluntary piece, and that's going to be really important, that imposing informal resolution is going to be contrary to the expectations of informal resolution. There's got to be voluntary participation, that it is a choice to forego or stop formal investigation and adjudication process. This is where there's probably some latitude of how schools may define this differently. Is it automatically that if you participate in an informal resolution, it could not proceed into formal or disciplinary process in the future, or are there trigger points in there? And the purpose of informal resolution, however you define it, will be that it's designed to reach a mutually agreeable resolution. And kind of parsing those three words. There mutually is not just the parties, but the institution has a stake in that. Agreeable may not be that it's what everybody asked for, but can we come to an appropriate compromise? And then what does it mean for it to be a resolution? Is it that this is something that will be revisited in the future, or is it really that this matter is now closed and not eligible for any other institutional action at any point? So there'll be more conversation as we move forward. And then, again, I want to remind us all, I feel like when we're talking about changing campus culture, that we sometimes will intertwine sexual misconduct and Title IX, and the reality is not all experiences of sexual misconduct do fall under Title IX, and it becomes increasingly important, at least in your practice, to think about that Title IX lens, that even when there is agreement to resolve something informally and your office determines that's appropriate, there's still the institutional obligation. Are you taking measures to stop behavior, prevent recurrence, and remedy effects? Next slide. So when we look at the spectrum of informal resolution, and I've added at the very bottom, the remedy and supportive measures, again, from our Title IX practice and many of us more broadly sexual misconduct responses, that those are always going to be options. The spectrum is informed by looking across practices that are used in conduct in education, in HR practices, and some of what we have seen in OCR and others as informing options. The spectrum is not necessarily less formal to more formal. The reality is you may actually utilize multiple elements of what you see here. But this framework does begin to think about how do we define in our practices and how do we communicate to others what are the available options to help resolve a matter or address a matter in a non-disciplinary way. So I'm moving forward kind of utilizing the common definition of informal resolution to be a non-disciplinary means to respond to a matter that could be a policy violation. Schools are going to individually need to determine how do you think of that definition, and do you need to spell that out in some sort of policy document or communicating it in some way to the broader campus community once you do make that decision. Again, some of you may already have some informal practices. This may be a new area you're venturing into. Some questions to ask at this point are these consistent options across all areas, students, faculty, and staff, or are there options that are available to some and not others? And if so, why or why not? Because then you're going to get into the equity piece of why would we allow some sort of informal resolution or access restrictions if it involves students, but we wouldn't offer similar to a faculty or staff matter. And there could be reasons for that. Often there may be additional stipulations in HR policy, in union contracts, in other sorts of things that might inform that. But beginning to ask those, if it's not the same, can we clearly articulate why or why not? This framework offers an approach also to think about how we communicate both the verbal communication with a party who may come forward and what needs to be written where as we think about options that are available. This is a broad overview, as I said, and is to some degree, and for some of us, maybe more new terrain, and for others, it may be, well, we've done this before in certain areas. How can we take what has worked in other ways and make it transferable to these situations? We're going to walk through each of the columns here on this screen. It's likely that you all may each have different questions based on your own experience and your own practice. So as you think of challenges, opportunities, or questions, if it's something you think others might benefit from, pop that in the chat to Carrie, or make some lists at the end. You'll get my contact information as well so that you can follow up. There's also, I don't know if you all are seeing on some of the slides, and Carrie, I expect will send out to you all some of the information I've pulled from different organizations. I've provided web links of those that should get to you so you can dig a little deeper on your own. So before we walk through each of the types of informal resolution, there's really some parameters that an institution is going to need to determine. So I want to talk a little bit about some of those decisions to be made and what might inform those decisions before we get into the options themselves. So probably first is the gatekeeping piece of what matters are appropriate for consideration. And for some of us who've been doing Title IX work for a while, that's the gatekeeping role of, is the behavior appropriate for this? And that's one means of looking at matters that are appropriate to consider. And certainly our advocacy folks are going to say we should not be doing informal resolution for sexual assault cases. I think there's increasingly some argument that that depends. It's not as clear-cut as that sounds. But even more than that, what information is needed in order to access an informal process? So my experience is largely at private institutions that have historically been really broad in there's some kind of conflict between two people, and sure, we'll help work through a process to help them come to some resolution, we hope. Public institutions may not follow that as much, or may put that more on housing staff or other offices to do that. But looking within your own context, what sorts of matters would be eligible for the informal resolutions as they're related to the spectrum of sexual misconduct? And certainly that may be informed by what your policies say with regard to, do you have a separate sexual misconduct policy? Are you looking at discrimination and harassment, and sexual misconduct falls within that? Is it a one policy, one process campus, or do you have multiple offices depending upon the roles of the parties involved? If you are operating with multiple offices who may address similar behavior patterns, how are you all coming together to look at how much information is needed for it to be this informal process? So if someone says, I don't want to give you details, but that person assaulted me and I just want you to help me with an informal resolution, is that enough? Or do you need a certain amount of detail, and what amount of detail would that be? Think about the range of options that are available and who is it that makes the decision. So you may have multiple options available, but certain behaviors, that what you've shared with me, this isn't going to be appropriate. Who's making that decision about what is or is not appropriate? Or it may be, who do you need to consult if there are multiple offices who may be informed in that process? But again, thinking about these decisions and identifying, does that mean there's some process that needs to be written to help us get to a place for that? And then finally, what's communicated to whom and in what way? And part of that is the policy, process, protocol, practice. What do we have in writing, and what are we doing, particularly if you are at a larger campus where there may be multiple people doing similar work? What needs to be put in writing, and what's already in writing? Is there anything in your current process document that either opens or closes opportunities that might need to be addressed, as well as identifying additional options to offer? And then also the communication of how will people know what's available to them. One of the challenges of informal resolution is we want to have latitude to speak to the specific circumstances and the willingness of the parties involved, what they're open to and willing to engage with, and have enough guidance so there's some continuity And how do we communicate that to folks? Those are some challenges that there aren't clear answers to that will continue to evolve, and I think folks may have some information sharing in the year ahead of what we experiment with or have had experience with that's working and not working. The other piece of communication is your record keeping, particularly for those matters that do rise to Title IX or VAWA policy implications. We've got to keep records. So informal might mean non-disciplinary. That very rarely is going to mean there's not some documentation. So then the question of who has access to documentation and how that's being communicated to the parties involved. Being clear about what happens next and what cannot happen next. So if part of an informal process is this means this matter is closed, how is that being communicated up front so that the parties are aware of that or the opposite, that in the course of an informal process, new information comes to light. Is there a point where that may redirect that we have to revisit whether informal is the right way to handle this? As I said earlier, these are all challenges that there aren't clear answers to yet, but things to be thinking about. So on the next slide, we'll talk a bit about defining some of these parameters. How is that informed? Certainly there is Title IX, the Violence Against Women Act, Section 304, and our own campus policies, whatever may be in writing on your own respective campus. So there's high expectation that the upcoming rulemaking, whenever that's going to come out, will follow some of what's in the 2017 Q&A that clearly and explicitly states informal options are available as long as they're voluntary. It's not kind of the folks who speculate about this, no one's expecting that it's going to get a whole lot more defined than that, but it does open the door for each of us at our respective institutions to decide what does that mean on this campus. A caveat of that is that VAWA requires communication of results. That's the language that is in the guidelines, the final writing of VAWA. So what does that actually mean? That we have an obligation to provide written outcome communication to parties when it is sexual assault, domestic violence, dating violence, and stalking. The VAWA regulations don't specify those are disciplinary outcomes. It specifically says results. So what does that mean in the way of how do we comply with our VAWA obligations while also honoring the wishes of the parties involved where appropriate that we might undertake a resolution process? Big question to continue to think about, and I expect at some point that might get posed to OCR to look for some guidance. I'm not sure how quickly we'll get an answer to that. And really paying attention to, as always, what are your own policies and procedures on campus, as many of you are probably undertaking final looks at updates for the upcoming academic year. Do you need to take another pass and see, is there anything else in your policy and process that would have bearing on your ability to offer informal resolution options in any of these parameters that I'm putting forward? So again, more things to think about. Next slide. So those of you who may or may not have regular access to ATIXA's materials in their listserv, some of you may have already seen this. This is a publicly available document and the link will be provided to you. But really kind of reeling us back into a position statement that ATIXA put out back in March as some of this conversation about rules and regulations and informal resolution was coming up, is coming back to the basics, again, specific to Title IX, and many campuses have sexual misconduct policies that extend to behaviors that impact community members, but technically are not Title IX. That's a parsing area that each campus is going to need to be mindful of. But the basics that ATIXA is communicating in the larger position statement that this quote was taken from is, in these moments where we don't have really clear guidance from the various federal agencies that are prone to provide us guidance and case law isn't there yet, this is a reminder of, first, the narrow field of, is this Title IX, which means it is sex-based discrimination. The behavior could be sexual misconduct, but it needs to rise to what is the discrimination that is at play for it to truly be Title IX. That's different from, as I said, many of our processes that talk about sexual misconduct. And then what if it's behavior that could be a violation of policy, but is not Title IX, particularly for those of us who have a broader policy? How are we parsing what decisions we're making? What stands out here to me, and why I put this in here, is to think about the power of language, that how you are both writing your documents, whatever they may be, policy, process, or internal protocol, how you're referring to things needs to align with how you're talking with others, and recognize of how, particularly with the national media that is so often using really broad strokes around Title IX and the work that we do, and sexual misconduct that may or may not fall under Title IX, really paying attention to language is going to be important, and paying attention from the institutional lens of, regardless of where you land on the spectrum of how you might refer to behaviors, particular attention to those things that do fall under Title IX or for which VAWA 304 is applicable, your additional obligations of making sure that you're being compliant while also providing options and we hope providing some resolution to the folks involved. So the need for information in this position statement may also speak to that gatekeeping role of how much information do you need. Here they refer to there must be tangible evidence. How much information do you need to trigger what sorts of actions on your own campus? Next slide. So when we think about the communication, that can get parsed into a whole bunch more questions. What are the policy and process documents, or where else is this information accessible? Some of us have more robust websites that talk about options. Some people have created flowcharts. Where are there places that the option of informal resolution will be or could be communicated to folks to know that it exists and learn a little bit about what it means? And then getting into an individual case when somebody does come forward with a concern, what else needs to be communicated to a reporting party? This is particularly relevant in the really being clear about the voluntary aspect of an informal process, and often to communicate to a reporting party that both parties have to be voluntary. So the reporting party may really want to do something informal, and if the responding individual is not going to agree to it, it's not going to work. So that can be an early challenge. Also, points of communication for any party involved is how are you keeping records, the difference between private and confidential, and how on your campus you're using both of those terms, because that can certainly be different. What's being communicated to all parties about what is this informal process? If it is truly a non-disciplinary process, which is how we're using that definition, what does that mean? Can there still be some restrictions even though it's non-disciplinary? I've seen some listserv buzz of people saying, well, if it's informal, then how are other schools going to know? I mean, for some of us, there's nothing that says we can't make with an informal resolution that part of the informal resolution may be, and the following statement would be shared if we were asked about conduct matters, and define it appropriate for the specific situation. But that's a big question that schools are going to need to consider. And then, as I mentioned earlier, how does a resolution implicate our obligations under 304? What's going to need to be communicated? What's going to need to be in writing because of 304, putting results in writing? What information can be shared and with whom? All of these are things that we probably already have some thought around with our thorough investigation and disciplinary processes. What's the similar or different answers to those questions when it comes to informal resolution? Next slide. I always think it's important to think about the construct of institutional betrayal. If you're not familiar with the work of Jennifer Freed out of Oregon, she's been, for the last decade or so, doing a lot of writing about the importance of managing expectations and utilizing trauma-informed practices, communication is such a huge part of that. It is always the case that we could do everything right according to what our processes say, and it's still not going to feel good because these are really unpleasant situations. However, if we are not communicating and managing expectations, we can leave individuals feeling traumatized by our process as opposed to being helpful in the process, even if people aren't happy with the outcome. So paying attention to that as we develop new ways of addressing concerns is going to be important. Providing an expectation of how we're going to communicate. And the reality from a trauma-informed lens is we probably want to have a conversation, and you're going to want to follow up with something in writing or something for people to take away, because we know that in conversation with someone who's a part of a process around sexual misconduct, that it is not uncommon for us to have a detailed conversation and then hear 2 days later that somebody said we didn't tell them that. So thinking about what are the multiple ways of communicating to attend to that trauma-informed practice. How do we create some guidelines that don't paint us into a corner we didn't intend? So allowing appropriate flexibility while also managing expectations. There's going to need to be more specific details, and how are you going to keep records and communicate as you get into coming to any sort of informal agreement. It needs to be agreement, but how are you going to document the agreement in some way? Because inevitably, if it doesn't feel good down the road, one or both party could come back saying, I didn't agree to that. So the many lenses of how are we keeping records and how are we being clear throughout the process of what records are being maintained, where are they being maintained, how are they being shared. Thinking about other places that information might get shared. I think a common one that comes up in residential campuses is if you have someone who is a participant as a responding party in an informal resolution, if they apply to be an orientation leader or an RA, is that going to give you pause as a staff member? And what about the other students who may know about this informal process and maybe saying, well, that person was accused, why are they allowed to do X, Y, or Z? There's not a clear answer, and there's always going to be someone who believes we haven't done enough or it wasn't appropriate. So thinking in advance of how do we manage expectations for ourselves and for our colleagues, that those sorts of situations are going to come up, and that doesn't mean that we've done anything wrong, but are there checks and balances that need to be put in place, or is it just preparing for pushing back when others may be questioning whether the process was thorough or appropriate? Again, more questions than answers, but ideally these are questions that are being explored to inform the practices and options that are available before the need to utilize those options will arise. As with all that we've learned in the last 6 or 8 years of investigation and resolution through a disciplinary process, we can anticipate that as we develop and refine our informal options, that we're going to need to debrief and revisit, and we'll probably tweak some of those things as we go on and continue to learn from one another in that process. So coming back, next slide, to the spectrum of informal resolution. I want to walk through each column, anticipating that some of you on the call may be in very different places of using some or all of these possibilities already. So for some, this may be some basics, and for others, this may be new information. I welcome you to throw into the chat if, as I'm talking or as you're looking at these options, you think of other things that aren't represented here that are worth considering. Please share those and we'll share them out. And again, the importance of considering broadly our need to be equitable and supportive or remedy measures that may be applicable throughout the process. So next slide, no contact directives and access restrictions are going to be situation specific. There is a detailed ATIXA position statement that's also a link that you all will have access to if you haven't seen it, that does a deeper dive into what's considered as far as no contact directives. Are they mutual? Are they unilateral? Are there multiple parties involved? What are the limitations? How do you define no contact directive? And that may be something that's already well versed on your campus or something that needs some attention. The challenge of when someone says, but they looked at me across the room, they violated the no contact. Is that happening often? Does that mean that you need to look differently at how you're defining no contact and how that's being communicated? Thinking about what is realistic on your campus. If you're on a small campus, you may only have one or two options for dining, and it might not be unreasonable for both people to be in the same place at the same time, but how does it become contact between the two, and the specificity of how you communicate that, whether detailed in writing or the communication verbally that goes with whatever's put in writing. Thinking about those sorts of presence, proximity, actual contact, contact through a third party, or some combination of those. Consider the duration of restrictions and how parties could request an update. So maybe there is a no contact expectation, and this year it seems very reasonable. They're in different majors and live on different parts of campus, or one's a commuter and one isn't. And then those circumstances may evolve that it needs to be revisited. Thinking about the application, is this between parties who may interact outside of campus, and to what degree would there be application of this beyond what's happening on campus? And the important question of what does enforcement look like? Who is monitoring or not monitoring, which is typically the case, where to report concerns, what are the consequences? And on your campus, if there's an allegation of violation, who addresses that? Does that go through a conduct process? Is that the same people who created the no contact? What is that practice? And then clearly communicating all of that information is important. There's two lenses of this. So certainly there's the protective aspect of no contact directives and access restrictions that may be a decision that you and your office are making more so than a request from parties involved. But access restrictions in particular could become an informal resolution option where a reporting party says, I just don't want this person, they actually aren't a member of this club, so could they not come to events by this club? I think in most cases an institution wouldn't impose that outside of a disciplinary process, but could facilitate an informal resolution that's an agreement of restricting access. And that might be what a reporting party is looking for, and under the right circumstances, a responding party may agree to some of those restrictions. So thinking about those parameters, not just as protective measures, but also how they might become a version of an informal resolution to address concerns as they come up. Next slide.
Hey, Amy, real quick, I have had a question, if you don't mind.
Sure.
So what are your thoughts on complainant's requests for informal resolution in the form of a negotiated agreement with the respondent for a particular outcome, i.e. suspension rather than dismissal? And do we need to create sanction guidelines and stay within those boundaries to minimize liability?
Oh, big questions. So a negotiated agreement for suspension gives me pause, because that feels like we're conflating. Suspension is usually a disciplinary action, so it's likely not really an informal resolution unless you're defining things differently on your campus. And I would encourage, if you have legal counsel, to involve legal counsel in any of that kind of definition. I hear in that more of a question about how much can a complainant weigh in on potential sanctions if there is a finding, is what that smacks of a little more. I think separation from the institution, particularly calling it a suspension, conflates things for me. What I have facilitated in my own experience on more than one occasion is where the responding party acknowledges that they need time away, often because it's intertwined with either a substance issue or a mental health issue, and a reporting party would agree to, I wasn't trying to get them kicked out for life, but yes, they need to go take care of themselves and need to not be on campus. So that could be an informal resolution, though my risk personally would be, I'm not sure we'd want to put that in writing to offer to people. That would be something of how do you have the latitude under circumstances where there's that kind of circumstances at play that you could come to an agreement. And some institutions may refer that less as an informal resolution and more as an agreement to stop a process to allow for someone to take time away. So I think there are some ways to consider that, but I don't know that that is an informal resolution per se.
Okay.
There was a second part to your question about some of the risks involved. Say that again.
Yeah, do you need to create sanction guidelines and stay within those boundaries to minimize liability?
So I, again, am going to be hung up on the language when you say sanctions. To me, that is disciplinary process and sanctions, so I would use a different term for that. If you want to identify, if you are on a risk-averse campus and feel like you're going to get more support if you have some clearly defined options or outcomes to anticipate from informal options, that might be a way to say it. You could do that, but then that also, it gives me pause to think about, are there unintended consequences of that? Do you lose some of the latitude that would be helpful? I think those are all good questions. They support why I'm going to keep saying language is really important, that we're not conflating things and that we're using language really intentionally to avoid some of that liability. And stay tuned. I think there are some campuses for either staffing limitations or risk averseness or other things may not venture too far into informal options until there's a little bit more practice around what's working and not working, and unfortunately what does or does not end up as case law is where I think there is some discomfort for all of us to consider is these, we don't have a lot of answers. We certainly can point to some practices in the conduct realm, a little bit in the HR realm of things that have worked in other ways that can work here as well.
And one more.
Yep.
What if the complainant refuses to submit to cross in a hearing, cross-examination in a hearing, and this is our only option to resolve the case?
That's a big what if. There's a lot going on in there. So I think my aspirational hope would be that we all get better about the upfront communication with reporting parties and to some degree witnesses about an expectation of participation and consequences of not participating. So there certainly is literature, guidance, case law that would say an informal resolution should be stopped if agreement can't be reached. And what you're talking about is the other direction. We really wanted to go through adjudication and we could be the institution and the reporting party. But if the reporting party is not going to participate, then adjudication is not an option. I have pause that if you've already been through investigation and gotten to the point of not participating in a cross-examination process, it may be harder for the responding party to willingly participate in an informal process. I don't know. But I think it's more of having those conversations earlier on, and to do that really carefully because you also don't want to be accused literally or figuratively of trying to dissuade people from pursuing a formal disciplinary process. So I think it's going to be a delicate balance, and we don't have all the answers to that, but that is why I posed in this the importance of these are some decisions that need to be talked about and grappled with before we start actually offering options to members of the community, so that we've gone through some of these what-if exercises.
We have one more question if you want to do it now, or if you want to move on, we could do it at the end.
You can throw one more out.
Okay. Would like your thoughts on written letters of apology or letters admitting responsibility in informal resolution.
Oh, that is a good question, and I'm going to suggest, let me run through the next slide quickly, and then I'm going to get to informal agreements, and we'll touch on those specifically. So educational measures, and again, I come back to my Title IX influence of indirect measures may be something you're doing regardless of what anyone else wants. That part of taking measures to prevent recurrence could be, hey, we need to update our education or provide some indirect education. Education may also be something that is an element of an informal resolution, but it's just one piece coupled with other things that happen. And in any of those instances, it could be indirect or direct. And indirect being, I don't want everyone in my fraternity to know that this happened, but it would be really helpful if the fraternity got some current education about alcohol and consent. So thinking about that way, a direct education is what types of education, this is maybe in the form of a relationship violence situation where the reporting party says, I don't want anything to do with them anymore, but I really want them to learn and understand that this was not okay and that they should get some kind of education. I think the decisions that you will need to make is what type of education. Is it you need to go engage in some sort of assistance and come back and tell us what it was, or who is going to define what constitutes that education, who's providing it, what follow-up or documentation is needed, who's participating. There's also the piece, if it is part of an informal resolution, what gets communicated back to the reporting party if we're talking about education for the responding party or parties to participate in? Is there some kind of reflection that's written that's then shared with the reporting party? Is it just confirming with the reporting party, I can tell you it's been completed, or is it just you're agreeing that we're going to make sure it happens and you're not going to hear any more from us? So that may be different for different circumstances, but is certainly something to think about. Next slide. So other types of informal agreements, and I'm offering kind of three particular areas that I'll provide some broad strokes, and I invite folks to throw some things into the chat for Carrie if you've got other things that you think would fit here that aren't mentioned. The ADR, or alternative dispute resolution, is where I cringe a little bit as a student affairs person, but for legal folks that might make more sense. Looking broadly at both of those. So getting into dialogue, often one or both parties are seeking to understand or be understood. This could create a whole nother spectrum of what does dialogue look like, but thinking about, is it that a reporting party says, I don't really want to talk about this, it wasn't okay, but I'm not sure how to approach them, and I would like to approach them. That might be some coaching on how to have that. It might be having a facilitated conversation or some kind of shuttle dialogue that a staff member is hearing from the reporting party about what their concerns are, is then hearing from the responding party and is taking, to some degree, some information between folks. So a lot of different ways that could be used, but thinking about, if the purpose is, I don't understand why they did this, or I don't think they understand why it was wrong, would often be indicators of where some form of dialogue may be reasonable. Other conflict resolution measures, and this may be where the question about a written apology or other sorts of things could fall into this. It's often some form of reflection, some type of acknowledgement, or engaging in some kind of mentoring or ongoing behavior. A couple of thoughts here. One is there are some folks in the field who push back on the term conflict resolution because it's actually not necessarily resolving the conflict. It may be coming to an agreement and the conflict is still there. So parsing of words can be something that folks may be up against depending upon what your campus community is like. When it comes to a written apology, and this is me speaking from my training and experience, that is not something that I would put out as a potential option, because it can be really hollow and it can actually do more harm than good if it's not well intended or well executed. And yet in some cases that may be what a reporting party is looking for. So would you consider that as an informal resolution? I'd be really careful about the parameters you put on that. I know that in conduct realms, when it's used, it is almost always used that the responding party needs to submit the written document to a staff member for review. And then, if it's appropriate, it's shared with the reporting party. That's a gatekeeping piece to make sure if somebody's highly inappropriate, it doesn't do more harm. But there's also the challenge of how much involvement can you have, and I think part of it is an upfront conversation with the reporting party. Having someone write an apology is not the same as somebody acknowledging their wrongdoing. So if the expectation is I want them to tell me that what they did was wrong, that's different. So setting expectations or managing expectations is going to be important on that. I think that the underlying behavior that brought you to this point is also going to be a factor, that there are certain behaviors that even if it's what the reporting party is saying they want, that alone is not going to be sufficient attention. It could be more along the lines of a reflection and some guided questions around, given what you know now, what information has been shared, what would you do differently? How have you reflected on this? What might you do differently in the future? If you had to share this with an incoming student, what do you hope they would learn? Kind of some more guided educational reflection pieces to it might be a reasonable piece to doing that. And then on the screen here, the other notation. So I listed mentoring because in some cases the behavior is that individuals are communicating poorly, and sometimes it could be both parties. So there may be opportunity to do a broader, someone is disconnected and so they're acting out, or they're not, they don't have someone to seek consultation with, and for longer term success, mentoring might be valuable. There are a number of schools who have some programs. The two I know of are James Madison and American University, two East Coast schools that have some mentoring programs they use. When we come to mediation or mediating efforts, and the capital N mediation is truly the legal term that here in Ohio, there are some legal obligations of who can truly mediate and what records are kept and that kind of thing. So be sure and consult with in your own campus community of if that legal connotation is going to have some bearing on what you offer or don't offer. Bricker and Eckler, and I believe that their webinar may still be accessible. Carrie, you may know that, so that you could go listen to their discussion from a law firm perspective about the importance of parsing language, but also thinking about how are you going to demonstrate that the person who's facilitating these efforts is properly trained, and what documentation is kept where are going to be important elements of that. Someone has asked all of these that we've come to so far, if a resolution can't be reached, is there still an option to enter a formal process? And if you go back to one of the early slides that I shared, that's a decision that needs to be made as to what your expectations and processes are as an institution, and something that needs to be really clearly communicated to the parties. So certainly it needs to be voluntary, and parties can withdraw their voluntary involvement. Up to what point is a decision making that needs to be made at the institution level and communicated in advance, as well as if we can't come to an agreement, depending upon what level of gatekeeping you have at the beginning, the consequence may be we can't come to an agreement, therefore we are now commencing a formal investigation. But is that always the answer? Part of that is a decision that is going to need to be made at your institution that probably is tied to what sorts of behaviors are you offering informal resolution for? Because if you're engaging in some kind of informal process because there's a conflict, but the conflict or what you know about it doesn't yet rise to sufficient information to commence an investigation, you might be stuck in there. I'm cognizant of time here, Carrie, and so I want to check in. I think that we're due to wrap up at 1. Is that correct?
That is correct, but for those of you who are on the webinar that do need to jump off for another meeting or commitment, Amy, if you're comfortable, we'll just continue to go through, even though we'll go over time, and I can provide the recording to those individuals upon their request for anything they may miss.
Okay. So next slide then, the restorative principles. I know this is something that folks are interested in hearing more about. I'll begin by saying first, these are really broad strokes. There's more to learn here and potential opportunity to have some more dialogue in the future with Carrie about this. So it's important to me to really make the distinction between restorative justice as a system and restorative principles that can inform our practices. There's a lot of information in there. The premise of restorative principles is really appealing because of that social science lens of strengthening relationships, healing harm, restoring community. Again, those of us who are educators, that speaks to us, and we want to be able to do that. True restorative justice systems are a system. They're not just a resolution option, and they're pretty complex, and they're rooted in lots of things. So I've provided some links that you all will get of where you can find more information. The biggest example in higher ed specific to sexual misconduct is the PRISM project. Coming out of Skidmore, where David Karp had been, he's out in San Diego now, but the project still lives on that website, and there's a great report that talks about some of the ways that a number of schools have been incorporating restorative practices into sexual misconduct situations. And then a lot of the work around restorative principles and restorative justice looks to work that's being done in criminal justice systems, and there are some areas of Europe that are way beyond us in doing that. So the next slide speaks to some of the complexity of the restorative justice system and the elements of restorative practices, and it is not until you're doing all of those things that you hit the center that is the restorative justice. So I share this just to give you the big picture of there's a whole lot more to think about, and there are ways to be somewhat restorative or be informed by restorative practices without truly getting to restorative justice systems. Next slide gives a little more information about that. These practices are appealing because it allows for the parties to be participants in the decision-making of resolution, and it's being used in a variety of ways that has longer-term effects of reducing crime and violence, bullying, increasing or improving relationships. The restoring community and repair harm is very much a way that restorative principles and practices are being used often in residential settings and conduct processes on a growing number of college and university campuses. It's important to me with the social justice lens that many of us bring to our work to really be sure that we're using care to acknowledge where restorative justice comes from, that it echoes a lot of practices from Native and other ethnic cultures, and so kind of seeing that connection is an important social justice lens. And then also looking at really communicating the purpose of restorative practices is repairing harm and has a community impact as well as value for the individuals immediately involved, and that it's very different than a model of punishing offenders. It is still about accountability. It is, and so it becomes really important of how we're talking about it. There are a number of resources. I'm looking for what the full name of IIRP of International Institute for Restorative Practices provides a lot of information, and the link is here where you can get more information. Quickly, some do's and don'ts. I've talked about these as we've gone through this, but we do want to determine our options and our practices in advance, and we do want to allow latitude for tailoring to the circumstances. So this comes back to the original list of defining parameters, what situations, what information is necessary, how are we maintaining information, when might new information change things, or when might we reopen something, if you will, or take something from the informal realm to the formal. How do we know we've reached resolution? And that's the air quotes of resolution. What does that mean, and how are you communicating that? As well as how do you communicate to the parties when this informal resolution has been achieved? And as the question that's already come in, what if resolution can't be reached? What are the options? Is there a point of, okay, if you no longer agree to participate in the informal, it must go formal, or then it will be looked at differently? That's going to depend on that first question of for what matters and how much information do you need would allow you to utilize the informal process might inform that. And I think the other thing to think about here is, depending upon the nature and size of your campus, might it be that there are options to which you can refer someone outside of your office that is different than an informal resolution, but still might satisfy that desire for something to be done? And if so, who's doing that? How do you make the referral? Who's keeping records? What gets communicated back to you in your office for your records? My big statement I say in lots of places, doing nothing is rarely a sufficient answer. So even when a reporting party is saying, I don't want anything to happen, there's always that risk management lens that we look at to say, but is there something we should be doing? And certainly, if nothing else, we're documenting. So remember the basic cardinal rule of following your own process and paying attention to what's documented, paying attention to what you have in place as far as case management. So even when there is some degree of agreement, what kind of follow-up or check-in are you intentionally doing, or how do parties know if they experience some tension or dissonance, who they can come back to either process that or seek other options? So I think what I haven't said explicitly, and I'll say for those of you who are still on the call, informal resolution is not easy and is not going to take less time necessarily than an investigation. And I think that's a point that practitioners need to be really careful about communicating within your own campuses. I know there's lots of buzz about our reporting parties going to not come forward, and we need to offer other options so that we don't lose the traction we've made. And absolutely, and informal does not mean that it's not going to take time, both man hours of the people who need to do it and the time from when information is brought forward and when there's some degree of agreement. In some cases, an informal process could take even longer than an investigation and disciplinary process. It depends on the nature of the circumstance, the people involved, and what sort of informal measures you're thinking about. And so to the extent you're able to give thought to a lot of these questions before you agree to try or add something to your process, that will help be intentional and make sure that we're managing expectations, not just of the parties involved, but our peers and colleagues around campus as well. The unfortunate reality, there's no clear rule to follow, and there's not yet case law about this. So it leaves us to grapple with this both individually on our own campuses and collectively with the help of ODHE, as well as the many organizations and entities that I think are going to increasingly weigh in on this and give us some good stuff to chew on and think about. It remains, as I said, even if it's not a disciplinary process, follow your processes and documentation and keep good records, making sure those records are not just what you keep maintained, but how are you communicating to the parties who are involved. That was the rapid fire wrapping up of the spectrum of informal resolution and some do's and don'ts and questions to consider. Carrie, are there some questions that are sitting in your queue?
There was just one, and I posted to the group as well. Of course, everybody is looking for templates or things so that, we don't have to reinvent the wheel. But I guess also to you, Amy, do you have a written notice template for informal resolution that if people were to contact you at your email address on the screen, you might be able to share with them or help them work through and develop?
So that's a good question. I would have to dig through. I bet I probably have a sample that I could de-identify of some communication from my past of where there's been an agreement to resolve. So I am open to the question. I don't have anything that I could immediately respond and shoot back to folks, but please feel free. My email address is on the screen. Feel free to reach out to me and give me more specifics of what you're looking for, and I will certainly see what I can do. And if I do come up with a couple of good examples, Carrie, I'll share them with you so you have them.
Okay. Yeah, specifically they were asking the proposed regs require voluntary written consent to the informal resolution process and written notice that includes allegations, requirements of the process, preclusion of formal investigation, and consequences resulting from participation. So building off the proposed regulations and, of course, whatever the final regulations look like, that's, as you've mentioned, will be an ongoing, evolving conversation. But, again, if anybody, per what Amy said, if you have specifics or you want to expand on that, you have our contact information and that you can reach out and contact her, and I'm sure she can work with you in some capacity. Other groups out there, if you know that you have something that you've been using and you want to, or you're willing to share, certainly you can always send that to me here at the Department of Higher Education, and I can send it out to the group on my next email blast with any additional information you would like me to place on that, any asterisks or anything like that. I'm certainly open to that, and I can also help get that out. So checking, I do not see any additional questions for Amy at this time, or at least from this specific right now to this webinar. You may have others filling up your inbox. But I want to thank everybody for participating today. And Amy, thank you so much for your time, expertise, and partnership as we continue to work through these pieces. And I look forward to many more conversations and working with you in the future. So thank you.
Thanks, Carrie.
Yep. Everybody have a great day and enjoy what time you have left before the school year starts. So thank you again for joining us, and have a great day.